suppose your response would be, well, one more doesn't really make a difference. But the point I simply wish to raise is that what the approach of this court must be in looking at that information. And the judgment of the Competition Commission in Competition Commission versus, let me just get that, got it here 1 second, Interaction Market Services Holdings. It's quite instructive because it spoke of the need to recognize that one was dealing with some issues that were relatively unique in competition law. It involved the intersection of law and politics. It involved the court having to sort of draw conclusions from economic data, which is very different from, in a sense, the day-to-day stuff that facts, proven, etc. So that's one important issue. And then secondly, it also recognized that in looking at allegations of cartel conduct, invariably you may have to resort to inferential reasoning. And ultimately, whether an inference is proved or not is to be established at the end of the proceedings. So to that extent, you probably would agree that we have to be guided by those considerations as well. It doesn't detract from what you said, but I just want to make sure that we locate what you said in that understanding of our approach to both the pleadings and the allegations that seek to suggest collusive conduct on the part of Nedbank, as well as ultimately the establishment of inferences and at which stage we satisfy ourselves that an inference has been properly established.
Indeed, Justice Colopin. Just on the first point, we did do a calculation of the total time which my client is alleged to have engaged in collusive conduct, and over a period of almost 7 years, the total time is 24 hours. And as I'd indicated, many of those instances are 3 or 4 minutes, and the question does need to be asked, well, what sort of cartel is this, where a party aligns its prices for 3 or 4 minutes with another bank? What is the point of doing so? As regards the general question...
I'm not sure that's a neutral fact. I mean, we don't have any evidence with regard to whether a cartel can bring down an economy in 6 minutes. It's possible. Or manipulate, so that factor is neither here nor there, not so. Just as midnight on New Year's Day is neither here nor there, if we take into account that the markets open throughout the world 24 hours a day.
Well, with respect to Justice Colopin, there is a section towards the end of the affidavit where the Commission explains in some detail how vibrant these markets are, and we're talking literally millions of trades a day across the world. And so the context in which the Commission itself recognises that this conduct occurred certainly does indicate that it's unlikely that this is certainly as far as my client is concerned, I'm talking specifically about Nedbank, is something that its conduct, if it is collusive, had any impact at all. But we deny, of course, that it was collusive. As regards the general principle, Justice Colopin, that you asked, yes, of course, these are matters that at the end of the day might have to be decided with reference to economic evidence and the like. The problems that we have are matters of pleading. They are